Hi, I'm Jim Cox. I'm an attorney at Mickey Hamlet in Charlottesville, Virginia. I'm delighted to add my chapter to the Living Library of the Real Property section of the Virginia State Bar. I've looked at a number of the previous presentations, and they've all been wonderful, and I hope this keeps up to that standard. Just by way of background, I've been practicing in the areas of estate planning, estate administration, and real property for 40 years. I've been with the same firm in Charlottesville, Virginia for all that period of time since I got out of law school at the University of Virginia. I don't know if that shows a lack of initiative or just being very satisfied with the practice area and the people I have practiced with, but I've had great colleagues over the years who have helped mentor me, and I hope that that's how I've paid back other people. Part of the reasons I've always been willing to participate in the continuing legal education program, whether it's something like this Living Library or with Virginia CLE or other programs, is I really think that it's a great way to keep abreast of things in the law and give back to the other people in the legal community to share some of the experiences and knowledge that I've acquired over what seems now to be a lot longer period of time than I can remember. As I said, my focus has primarily been on estate planning, estate administration, and real estate, and that's why we're here today, is to talk about kind of the intersection of those practice areas. Anytime you're dealing with real estate, a lot of different areas of practice can come involved: commercial work, corporate structures, company structures. But estate planning, I think, is very important to understand both the issues regarding the need to make sure the estate planning is done right, and then on the back end, after somebody dies, how things are distributed out at that point in time. And my colleague Paul Melnick and I are going to discuss that in a separate joint presentation. So I'm going to focus right now on kind of what you do for a client during their lifetime. One thing that's always important is to know what tools are available out there to help you in advising clients. And just like most real estate practitioners are very familiar with Title 55.1 to answer questions regarding real estate, most of the answers that you need, and one of the volumes that you need to have at your disposal of the Virginia Code is 64.2. It is now pretty much that title deals with everything regarding estates, estate planning, and estate administration. It's a very helpful tool. Of course, there's always a lot of different materials from organizations such as Virginia CLE and others that can supplement any of these topics that we're talking about. In this short period of time, we can only give you the briefest of overviews. But there are various other options to deal with that. So when somebody comes to you and a client comes to you and asks, oftentimes they say, we need a new will. And that's rather limiting. People talk about estate planning, and that's kind of encompasses all the different aspects of what decisions go into people planning for their estate, both things during their lifetime and at their death. And it's important to take in consideration all those issues. I always worry when people come in and say, look, I just need to do a power of attorney, I just need to do a will. I don't really think it's helpful or conducive to the client's need to just look at one focus. Anytime a client comes into you to ask for some help with a particular aspect of estate planning, you really need to get the full picture so you're not doing something that's going to undermine another aspect of their estate plan. And when I talk to a client about estate plan, I usually try to kind of shorten it down to 3 different issues that we're trying to accomplish at that point in time. One is making sure your assets get to the right beneficiaries. That's kind of the fundamental role of a will or a revocable trust if you're going to use that as a probate avoidance tool. The second thing is make sure you have the right decision makers in place. And quite frankly, that may be as important, if not more important, because these are the people that you're going to trust to carry out your desires at your death, and also the people you trust to carry out your desires or be your agents during your lifetime. And the third thing is there a way to plan your estate to make sure that things are kind of as efficient and economical with less strife and issues at the time of death? And that's usually by a combination of beneficiary designations or trust or survivorship provisions. So it's really important to look at all those aspects of it. One thing I do want to focus on, because it comes up a lot, is the role of powers of attorneys. Again, this may be in some instances the most important document that people execute or consider executing. When for a lot of families, the default rules in Virginia estate as far as who will inherit your estate are exactly what you want. But if you do not have a written financial power of attorney in place and you become incapacitated, then no one, even if you have a spouse of 50 years, does not automatically have the right to act on your behalf. And the trouble is, if you do not have a financial power of attorney, the downside is that the only option may be to go to a court proceeding of a conservatorship or a guardianship, which is time-consuming, traumatic, and expensive. So you want to try to avoid that. But you have to always advise your clients that this is an extreme position of trust, that you have to have the particular person who you want to be his agent that you trust. Now, how does this come into play with real estate transactions? Well, a lot of us, are very familiar with that. At the last moment, somebody who needs to sign a document is not available, and then you get a specific power of attorney for that purpose. Most power attorneys that estate planners do are general power attorneys, which give broad authority and not just limited to a real estate transaction, but encompass the ability to do real estate transactions. So if you have that in place, then you may not have to go and get a real estate a power of attorney, a specific power of attorney done at that point in time. The other issue that people raise with respect to power attorneys is they always have a concern of, well, if I name this person as agent, are they going to be running around the country, getting access to my funds and doing something contrary to my desires? Well, of course, that would be a breach of their duty as agents, but it's a concern that people voice. The one issue that they want sometimes is what is often called a springing power of attorney, one that comes into existence upon a particular event, which typically is the determination of incapacity of the principal. I think most practitioners do not favor springing power attorneys for a number of reasons. One is incapacity, determining that by a physician is often very difficult, and so that may not be something that happens. Probably more prevalent is, capacity is never sometimes just a black and white issue. It may be kind of a continuum where somebody is slowly, losing some ability to make decisions. And quite frankly, a lot of times it's not a question of capacity, it's just a question of people not wanting to handle things. They want to turn something over to somebody else. So even though they have capacity, they just want somebody else to handle things. My real retort to people is, if you don't trust somebody to be your power of attorney when you're competent and capable of looking after when making sure what they're doing is right, why would you want that person to be your power of attorney when you're incapacitated and you can't look over their shoulders? So I think generally when you talk to people about that, they usually come around to the idea that perhaps a springing power of attorney is not the effective way to do that. But power attorneys are important because in the real estate transaction, in the estate planning, because there are certain powers in a power of attorney that have to be explicitly stated if that person is going to do certain things. And those are typically things that you might want to do in estate planning. For instance, in Virginia, under the Uniform Power of Attorney Act, which is under 64.2, the Act specifically requires that if you're going to give a power of attorney the right to make gifts, or the right to name beneficiary designations, then it has to be explicitly stated in the power of attorney. And for that reason, if you want someone to be able to make a transfer and death deed on your behalf, that has to be specifically referenced by giving the power of beneficiary. Now, again, it's kind of rare that people will use that, but you do see those in change of title sometimes, and then you always have to look at the deed in the power of attorney to make sure that the power of attorney authorized either the gift or the beneficiary designation in those circumstances. Because if not, then it's invalid. There's a couple of cases in recent Virginia Supreme Court cases where people exceeded their authority as power of attorney, and those deals were undone even after the death of the decedent. So that's on the power of attorney. On the issue about disposition of real estate. Now, again, the real estate often is one of the most important, if not the most important asset that someone has that they want to or think about disposing of at the time of their death. A lot of people have the desire, say, I'd like to keep this in the family. That becomes harder and harder to do just because if you're owning property with a number of people at the time of death, like you're giving it to 4 children or or cousins or something like that, then you have the issues that most real estate practitioners know. When you have joint ownership, you've got to make sure that everybody is going to work together. So I tend not to want to do that unless it's something very special. But again, you got to craft your will or your trust to the desires of the client. One thing that becomes an issue at the time of sale is how you designate the real estate to pass at death. In Virginia, if you say I'm going to give my residence directly to, my son or daughter, and you name that person, then that goes to that person directly at the time of death. This is the estate, the real estate drops like a rock. But if you give it and you say I give and devise all the rest of my remainder of my real estate, or rest of my remainder of my personal real estate in equal shares among 4 people, then the concern there is that all 4 people then own the property. I think, again, when you're drafting documents, it's important to see whether you want to make sure the executor has the power of sale over those properties and to distribute the proceeds among people, or whether you want the real estate to go directly to people. Another great concern that has come up in the last 20 years is how you deal with mortgages in real estate. In 2007, the law flipped, and now if you don't state specifically a person who receives a piece of real estate takes it subject to the mortgage. Before that, the law was the other way, that if you didn't say otherwise, the mortgage was exonerated or paid off from the residuary estate. So you have to be able to ask these questions to clients about specifically what they want to do with the real estate. And again, one of the big concerns is potentially having dispositions that may go to minors, because most real estate practitioners understand the problems that are associated with a minor if in case they inherit or own a piece of property through inheritance or otherwise. And so you need to make sure that if there's going to be something that goes to a minor, that it's gone to somebody in a representative capacity, either somebody as a custodian under a uniform Transfer of the Minors Act or under a trust for their benefit. In all these things, it's of course imperative to make sure you communicate to the clients what their options are, and to understand and listen carefully to what their desires are. I think that kind of the 2 most important communications you have with the client are your initial letter to them and the closing letter. The initial letter kind of outlines what they have said to you and what the documents you have. I think it's bad form to simply say, hey, thanks for meeting with me. It was a great meeting. Here's a copy of the will. Review it and get back to me. I think you need to, in that letter, communicate why you did the documents the way you did, what's the purpose of that, so they have that there to look at now and look at 10 years from now when they might revisit the issue too. And the same thing with kind of closing off the representation with the client. It's important to, again, clarify what you've done and where the original will is, and also what steps they need to take after that, how they need to change beneficiary designations to work with the plan, whether they need to retitle assets in the trust. Again, those communications are helpful because the client's going to turn to those probably first when they try to look back and see whether they need to make changes, in 10 years or 20 years. And then also, after their deaths, the family members are going to see that and they're going to understand, look, this was something that was done thoughtfully and that they understood what they were doing, and, they had counsel who outlined everything, so there won't be any confusion as to whether or not this was something that was done at the last minute. So all these kind of issues regarding real estate and estate planning, it's kind of just the tip of the iceberg. As I said, there's plenty of material out there where you can go to seek a little more detailed information about some of these topics. As always, anytime I do a talk like this, if you have any particular questions or emails about a particular topic, please contact me. I think that's one of the things I enjoyed having this kind of feedback. But I hope this has been helpful. Thank you.